All right, hi, I'm Nick Cohenmeyer, and today I'm going to be discussing the California residential landlord's right of entry, specifically the rights and restrictions for residential landlords in California to enter their tenant's dwelling unit. Now, of course, gotta have some disclaimers because this is law and I'm a lawyer. I'm not your attorney. I am an attorney. I'm authorized to practice in California. If you are outside of California, do not use this advice to apply to the landlord-tenant statutes in your state. This is only for California, and this is only for residential leases or month-to-month rentals. All right, so for the rights of entry for California landlords, in general, what is the landlord's right of entry? Well, normally California law permits a landlord to enter the tenant's dwelling, provided that certain requirements are met and proper. For example, you have to give notice to the tenant, right? Is that verbal? Is that written? Well, it depends, and I'm going to talk about that today. And of course, with almost any law, there always are exceptions. So we have to talk about the rule, and then we'll talk about the exceptions. But don't let the exceptions swallow the rule. So let's go in order. We're talking about the rules first. So some typically valid reasons for a landlord's entry. One, if the landlord needs to enter because of an emergency. Two, to make or supply necessary or agreed upon repairs, decorations, alterations, or services to the tenant's dwelling unit. Three, to exhibit the unit to active or potential purchasers, mortgagees, tenants, workers, or contractors. Four, to make certain types of inspections. Five, for purposes related to the metering for water service in a multi-unit, multi-family dwelling or mixed-use building. Six, when the tenant has abandoned or surrendered the premises. Seven, if there's a court order mandating such. And eight, to inspect exterior elements such as balconies and decks and their associated elements. All right, so when can a landlord enter the dwelling? Well, normally the landlord can only enter the tenant's premises during normal business hours. But what and when are exactly normal business hours? So I will address that. And it's problematic because in California, there's not specific normal business hours. And here's why. Let's say your tenant works like a swing shift or graveyard shift. So you would have a different, potentially negotiated opportunity to inspect your tenant's dwelling, right? So this can be negotiated, and it should be, between the landlord and the tenant. Now, in general, the normal business hours are going to be roughly the same for most people that work normal business hours. But to the extent that you, as the landlord, property manager, on behalf of the landlord, can negotiate a mutually advantageous schedule for inspections with that specific tenant, if you have the personnel to do so to match the tenant's availability, then you should. So the landlord should follow normal business hours, and that means generally, what you'd expect, approximately 8 or 9 a.m. to 5 or 6 p.m. That's a safe bet. But of course, there are always exceptions. Let me talk about this a little bit more in the next slide. So while normal business hours are not statutorily defined, courts have recognized that normal business hours can be reasonably interpreted as objectively reasonable hours under the facts and circumstances of the case. So this still doesn't really help much, right? But objectively reasonable hours under the facts and circumstances of a case can actually include weekends, such as when the owner wants to hold open houses to show the dwelling to prospective purchasers, and other exceptions. So there was a case in 2013 called Dromi versus Lukowski. And in that case, the court found that normal business hours could include open houses twice a month, albeit with safeguards to protect the tenant's personal property from third parties, as well as some limitations on the number of hours that the dwelling could be shown. Right? So it's not an unreasonable amount of showings. It's not unreasonable hours of the day, and I can't say just act reasonable because that's a subjective analysis, but go by what would be reasonable under the facts and circumstances of the case. And here's a tip, not legal advice, just generic suggestion. If you are contracting with your tenant, especially at the onset of the lease. This is the best time to do it. Work it out with your tenant at that time. What would be the normal business hours for you? What is your conception of it? And if the two of you can agree on it and put it in writing and get it mutually signed, then you have a much better chance of the court accepting that. If it's signed by both parties without any kind of duress and they both fully understand what they're writing. If you have a tenant who doesn't speak English as a first language, make sure that tenant has the right and opportunity to get an interpreter so they fully understand what they are signing. So what about inspections? Right? This is a big one because landlords always can come up with a reason to inspect the tenant's unit, but does that mean it's valid? Well, it depends. When does it ever not depend? When is that ever not the answer? It depends. It always depends. So landlords are not permitted to arbitrarily enter a tenant's dwelling unit simply for the purpose of inspection. Rather, inspections need to be negotiated with the tenant beforehand or be based on one of the aforementioned authorized bases for entry. We talked about that in an earlier slide. So another area where a landlord would be wise to detail the types of necessary services that would justify entries, such as inspecting for smoke and carbon monoxide detectors and to address a tenant's complaint about appliances or other accessories inside the building, would be this. This is where you should put this in your clause, the relevant clause under your lease rental agreement, of what type of inspections will be routinely necessary for the landlord to have authorized and properly noticed entry into your tenant's dwelling unit. When I say properly noticed, that means the notice was given properly. So there are many types of inspections that are presumed valid unless they can be shown not to be. So the default is these are valid inspections. And if you look at California Civil Code sections 1941, 1954, the Health and Safety Code sections, starting with section 17920.3 and the associated sections, you'll see that there are many authorized inspections that are generally permitted. You still have to give notice, but they can't be unreasonably withheld by the tenant. So generally permissible inspections would include, but not be limited to, mold growth, exterior stairs, decks and related fixtures, carbon monoxide detectors, smoke detectors, right? Those bases are presumably valid if the landlord is not abusing it and is actually entering, not just based on that type of notice, but actually performing that type of inspection. All right, so I hope it's obvious and hope it goes without saying, if you're the landlord, this is to you, don't claim that you're going in to inspect the carbon monoxide detector, especially if you've already inspected it that year and it's working fine, unless that tenant has complained or you haven't inspected it within a year or so. Don't use that as a false pretense. You're going to get yourself in trouble. All right, so what are some of the notice requirements? Well, in general, the landlord has to give the tenant reasonable notice in writing. Now, of course, there are exceptions, and must only request to enter and actually enter during normal business hours, okay? So don't make routine, harassing requests to enter at all random times of the day. Try to keep it consistent, try to keep it minimal to just what is necessary. Now, if you are asking for repeated entry because of a problem that is obvious or a problem that was brought to your attention as a landlord from the tenant, that changes it. That makes repeated entry and repeated requests for entry valid. And if you can contract with the tenant to get entry without the tenant's permission for a prolonged period of time, such as a week or two, if you're doing a kitchen remodel or addressing an issue that the tenant brought to your attention, that's probably fine. So try to put that in writing with the specific date that it starts, the end date, maybe it's a week later, and the reasonable hours of those days in between that you and or your contractors will be entering and leaving by. And do your best to adhere to those. All right, so when can an oral notice be valid? Now, written notices are generally the best, but they're not always strictly required. So the requirement for a written notice can be relaxed when the tenant and landlord have orally agreed to an entry for the landlord to make repairs or supply services that the tenant and landlord have previously agreed on, so long as the oral agreement specifies the date and time of entry within 1 week of the agreement. So you can't make this for just like some indefinite period in the future. Keep it specific, keep it limited. And in addition, the landlord can give oral notice in person or over the phone at least 24 hours prior to the planned entry if the landlord intends to show the unit to prospective or actual purchasers. Now, this requires that the landlord or landlord's agent has given the tenant notice in writing at least 120 days prior that the property is for sale. All right, so we talked about written notice, oral notice, but what are the cases where no notice is required? Well, under certain circumstances, no notice is actually required if the landlord needs to enter in response to an emergency, a legitimate emergency, or if the tenant is present and consents to the entry at the time that the landlord seeks to enter. So if you are knocking on the tenant's door, there's an urgent and legitimate reason you need to enter the unit. If the tenant says, yeah, come on in, you don't need a writing, you really don't need any formal oral language, just, hey, can I come in to look at the microwave that you asked me to look at? Yeah, come on in. All right, that's probably fine. Now, also, if the tenant has already abandoned or surrendered the premises, then that's another case where no notice is required. How should the landlord deliver the notice of entry to the tenant? Well, a landlord can mail the notice of entry. However, the notice needs to be mailed at least 6 days before the entry. Now, if the landlord wants to personally deliver the notice to the tenant or leave the notice on, near, or under the usual entry door of the tenant's premises, the landlord can do so long as it's done in a manner in which a reasonable person would discover that notice. Now, as you can guess by now, we're talking about how often is too often for entry. The legislature of California has not placed a specific number on the amount of entries that would constitute harassment. But under California Civil Code Section 1954, a landlord is prohibited from becoming excessive or unreasonable with the number of requests to enter the tenant's unit. So if you, as a tenant, feel that your landlord has acted with a significant and intentional violation of California Civil Code Section 1954, you might consider speaking to a lawyer first, if you are able to afford one and meet with one, in order to discuss your rights and remedies. Right? Almost always a good idea to speak to a lawyer, but do some research beforehand so you ask better questions and you can answer the obvious questions and get some at least background understanding of the procedures of the civil code, so you can hone in on, well, I think that my landlord has been intentionally violating my rights. I think it's a possible violation of California Civil Code Section 1954, rather than just leaving it vague and then having to spend your money for the lawyer to spend his or her time looking up maybe possibly irrelevant civil codes. Have them hone in directly, and that might save you time. Of course, the lawyer should know all the associated civil codes and health and safety codes that might be applicable, but you want to at least refine the scope, make it as specific as you can based on your circumstances and your knowledge. What are some of the consequences for a tenant's denial of entry? So while we've mainly discussed the rights and obligations of landlords in this case, the civil code sections are really bilateral. This means that the obligations exist for tenants as well as landlords. So if a landlord has provided proper notice of a lawful entry and the tenant refuses the landlord's otherwise lawful entry, the landlord has a few options. The landlord could start with a 3 or 30 or 60-day notice to quit, depending on factors such as how long the tenant has resided there and what covenants the tenant has agreed to in the lease or rental agreement and has breached. And if the tenant continues to refuse the landlord's valid entry, the landlord's next step might be to proceed with an eviction, which is known in California as an unlawful detainer. Now, a landlord may also consider bringing a small claims action for damages resulting directly from the tenant's invalid refusal to a landlord's valid right and notice of entry. All right, so what key terms should be in the notice? Well, a landlord should have a form at the ready that will provide notice of landlord's intention to enter the tenant's dwelling unit. So some provisions that you should consider including in your form that you might want to consider having just a blank form that you'll fill in as needed should specifically mention California Civil Code Section 1954 to give the tenant notice of what legal authority you're acting under and give the tenant an opportunity to look up the statute to see what the tenant's rights and obligations might be. So in addition to that, make sure you include that tenant's full address. So the dwelling unit number as well as the whole address of the property. Make sure that you include the day, the date, and the approximate time for your planned entry. And you should also include several blank lines so you can include the purpose of your entry in specific and sufficient detail. And lastly, you should offer the tenant an opportunity to notify you of a more convenient date and time for entry if your proposal is unworkable for the tenant's schedule. Remember, we talked about some tenants who might be working in the swing shift, the graveyard shift. They might be working in a factory, in a hospital. Try to make reasonable accommodations for them. Don't just strong arm and say, this is how I do it for everybody else, this is how it's going to be for you. Just because you can do something, and I'm not saying you even can in this case, doesn't mean you should. It's a lot easier for you as a landlord to offer some accommodation to your tenant, because happy tenants make your life as a landlord much less difficult. So if you're not motivated by any other motivation, motivate yourself to help yourself by keeping your tenants on your side. So make sure to tell the tenant how far in advance they need to notify you or request a change, and make sure you provide your full contact information if your proposed day, date, and time is unworkable for them. All right, so that has been my presentation on a California residential landlord's right of entry into a tenant's dwelling. I hope you found this helpful. Please leave your feedback, whether it's bad, which I don't have to tell anybody on YouTube to leave bad feedback, that's a default, or if it's actually good and you actually found it helpful. All right, that would be a pleasant surprise. If you want me to cover another topic, please suggest it below, and I will keep making these as long as people keep finding these helpful.